If a level 3 sex offender makes an application to lower their risk level to a level 1, and they've been crime-free for 19 years, does a judge refusing to grant that application constitute abuse of discretion as a matter of law? To find out, you have to read People versus Shader, but it's 30 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Shader. The citation for this case is 2024 New York Slip Opinion 05873, published by the New York Court of Appeals on November 26th of 2024. The issue in this case is whether a trial court abuses its discretion as a matter of law by refusing to lower a sex offender risk level from a 3 to a 1, even though it's been a long, long time since any sex offense has actually taken place with respect to a sex offender. To understand and appreciate the context of this case, the background that I think is helpful to know is that the Sex Offender Registration Act, which is people call SORA, creates 3 different levels in New York of risk, 3 different levels of a sex offender's risk. Level 1 is the lowest, it's low risk of reoffense. Level 2 is moderate risk, and level 3 is high risk for reoffense. And depending on whether, and after a person is convicted of a sex offense, they have to go through a hearing to get a sex offender risk level. And depending on what level they get, depends on how often they have to report, what kind of information the public has about them, whether their photograph is online, whether they have to report every 90 days. There are a lot of things that go with each of these different levels. But it's not a static risk level for the rest of a person's life, theoretically. Under Corrections Law, Section 168-0, Sub 2, a sex offender with a current risk level can petition to modify the risk level. So a level 3 sex offender can make a petition to the court and say, I want to be a level 2 or a level 1. And the court has to grant a hearing and order an updated risk assessment evaluation by the Board of Examiners of Sex Offenders. And there's a hearing at which the defendant, the sex offender, would have the burden of proving that the requested modification is appropriate by clear and convincing evidence. And the judge is the person that decides whether that burden of clear and convincing evidence has been met. And an appeal can be made based upon abuse of discretion if the judge fails to properly apply the law and properly assess the factors properly. So what are the facts in this case? The facts are that in this particular case, Mr. Shader has a significant sexual offense history that started when he was 12 years old. Allegedly in 1968, at the age of 12, Mr. Shader exposed himself in school. A couple of years later, in 1973, he allegedly committed a date rape and was convicted, replaced with a juvenile delinquency kind of a adjudication of sexual misconduct. In 1974, the following year, he allegedly followed 2 women who were leaving a bar and attempted to grab them. One of them fled. The other one he did grab and molested and fondled and threatened to rape until it was interrupted. He was convicted of attempted rape 1 and sentenced to prison. And then a few years later, in 1977, 1 month after he was released from prison for that previous incident I just talked about, and while he was still on parole for the sex offense, while he was 19 years old, the defendant broke into the home of a stranger at 3 a.m. and raped the female woman inside, raped and sodomized her. He was thereafter convicted of rape in the first degree and sentenced to 8 1/3 to 30 years in prison. He served 21 years in prison. While he was in prison, he completed a sex offense training program, and in 1998, he was ultimately released. He was released. He was determined to be a level 3 sex offender, which is high risk of reoffense. And while he was on parole in 2003, he was convicted of 2 misdemeanors unrelated to sex offenses, one of attempted possession of burglar's tools and one of attempted auto stripping. No other convictions since then, since 2003. In 2021, so 19 years later, the defendant petitioned the court under that Corrections Law 168-02 to lower his risk level from a level 3 to a level 1. He argued in his petition at his hearing, he completed sex offenders treatment, he held a full-time job, he had a relationship with his wife, he's been in a stable marriage, he was the father to his wife's daughter, 66 years old, he's fully complied with all the SORA regulations, the Board of Examiners is not opposing his application, and he had an expert psychologist examine him and say he's a low-level risk of reoffense. The people opposed the application, and the judge, now having this application before him, or I think it was him, decided that the defendant had met his burden of lowering the risk level, but not to a 1, but to a 2. At that point, the defendant appealed. Mr. Shader appealed and said the judge abused his discretion as a matter of law. The argument he's making is, yes, I have a significant criminal history, but the judge relied too much on that criminal history and not enough on the fact that I'm 66 years old. I've been crime-free for 19 years. I've done all these things in my favor. And the appellate division, upon appeal, says no abuse of discretion. It goes to the Court of Appeals. And here, interestingly, we have a 4-3 split of opinion. The majority in this case concludes that the judge did not abuse discretion, did not, in granting the petition in part and denying the level 1, because it's up to the judge. That's why we pay judges to analyze, to conduct hearings, to evaluate all the factors. And the judge was not wrong, as a matter of law, to consider the sex offense, the previous significant sex offense history, in deciding to deny the level 1 adjudication. But there is obviously a dissent by 3 judges who said the judge should have considered the other stuff more, and criticizing the system where a defendant's previous sex offense history, which is static, will never change, is being factored so heavily in determining whether a lower risk level is more appropriate at this point. But that's the case of People v. Shader. It's not an abuse of discretion for the judge to consider the previous sex offense history so strongly and to deny the application to go to a level 1. And that's the case of People v. Shader. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.